Moving swiftly along, we are back in Johannesburg on the 17th of May 2024. This judgment, GW versus MH, landed under the pen of Todd AJ, and that was bundle page 25 for those of you who are following along in our resource bundle, and the summary is on page 2 of your summaries. This is PD and another versus AR. Sorry, my apologies. GW versus MH 2023 120036 2024 ZAGPJHC 467, and that is the Safley reference. Now, what happened in GW versus MH is a dispute between unmarried parents over the applicant's right to overnight contact with a 2-year-old daughter. The parents had previously managed their parental responsibilities and rights amicably, but some disagreements arose over sleepover contact as well as financial support. The court was approached to provide interim relief to include sleepovers with the child. The respondent opposed it, citing concerns for the child's well-being. Now, the issues raised in this matter, obviously, as in the case of all contact and care issues, Section 28(2) of the Constitution and Section 7 of the Children's Act, obviously being that the best interests of the child are paramount. The court also held that the courts must adopt a balanced, child-centered approach, which should be informed by constitutional values and should be sensitive to culture and religion. In this instance, the applicant's request for overnight contact was deferred until the appointed psychologist provided a report on the best interests, the court obviously taking a conservative approach and erring on the side of caution. In the interim, the child was to reside with the respondent, and the applicant would have specified contact times without overnight stays. Costs for the psychologist would be borne by the applicant, and the applicant was ordered to pay 50% of the respondent's costs to date. The notable quotes from this judgment, I had 3 that I found, 2 of which are on your screen. The third one is on the next slide. The best interests of the child are paramount. Court must take into account the considerations set out in Section 7 of the Children's Act, and the court should adopt a child-centered, balanced approach informed by constitutional values and sensitive towards culture and religion. Nice quote for heads of argument in terms of setting out the approach to be adopted. That's paragraph 12. And then paragraph 17 being the turning point, really, of the ratio of the court. I'm unable on the evidence before me to reach the conclusion that it is, in fact, in the best interests of the child to have sleepover contact with the applicant at this point in time, before the parties have received the benefit of the expert advice and assistance of their chosen psychologist on this question. And then finally, interesting one in terms of dispute resolution. It is certainly regrettable that the parties have found themselves unable to reach agreement on these things. They have many years of co-parenting ahead of them, during which I have little doubt it would be in the best interests of the child if her parents are able to conduct their arrangements in a consensual manner and are not in conflict about them. Obviously, very, very much an approach that adopts Section 6(4) of the Children's Act, that there must be a problem-solving and a non-confrontational approach, and certainly sensible advice to all parents of small children embroiled in litigation.